you, Naureen, for this introduction. I feel very privileged to be able to take part in such a wonderful online course on genocide and justice organized by the Center for the Study of Genocide and Justice in Dhaka in Bangladesh. And actually, because of this invitation, I feel like I can, at least virtually, but I can come back to Bangladesh after a couple of years, because I was also privileged to be a participant or even a lecturer during one of the summer schools in Dhaka in 2013. It was also a chance for me to make or conduct field research in the International Crimes Tribunal in Dhaka. Finally, this research was concluded in my PhD dissertation on the victims' justice within the transitional justice paradigm, and I wrote a sub-chapter on the International Crimes Tribunal as sort of a mechanisms of delivering justice in criminal sense, but also in this new tendency of international criminal justice, also taking care and taking into account the position of victims of grave violations of international humanitarian law, international crimes committed like genocide in your country, in your case, and it was my first time in Bangladesh. So thank you that I can at least virtually can come back for this 1 hour to Dhaka. Today's lecture, and if it's possible, I would like to also display my presentation. So Naureen, if you can share the screen with us. My today's lecture, today's presentation is devoted to the issue of transitional justice in ongoing conflicts and post-war reconstruction. It's like I said before, transitional justice as such, as a field of my research, I can say I'm quite experienced in that field since at least for now 10 years of research, of doing research in different parts and different angles of transitional justice. Of course, because I'm a lawyer, international lawyer, so my perspective is basically the international legal perspective. Nevertheless, I also include the case or the importance of human rights, but also non-legal issues, since they are also a part of a bigger concept of transitional justice that I'm going today to describe for you, at least my understanding of transitional justice. If we can move on to the next slide. Yes, main goals of my today's lecture. I would like to concentrate basically on transitional justice in ongoing conflicts and post-war reconstruction, the importance, significance of such processes. Nevertheless, and since Naureen has just underlined that during the course you had a lot of speeches on international criminal justice and international tribunals, but you did not have a separate lecture on transitional justice, so I will start my presentation on defining this concept and showing the constant development of transitional justice as such. Of course, taking into account the international legal perspective. Then, the main core of my today's speech will focus on the issue of different transitional justice mechanisms that can be applied during the bloodshed, so during the ongoing conflicts, either non-international or international armed conflicts, and during the post-war reconstruction, emphasizing basically the importance of international judicial interventions, so the use of international tribunals by the international community, for instance, during the situation of the international assistance in conflict or post-conflict situation, even in the situation of non-international armed conflicts, and the possible establishment of the so-called international transitional administrations, established mostly by external actors. In most of the cases, it was established by the UN, basically the UN Security Council, but also UN General Assembly that was assisting in different cases. And finally, I will try to draw your attention to the case of actually my neighbor, so Poland's neighbor, Ukraine, which, as I can imagine and understand, it's not so often discussed in your situation. But first of all, it's since a couple of last years, it is my concrete field of research, that is the application of transitional justice during the armed conflict in Ukraine. But also, I would like to draw your attention by showing this example, because of the fact that in a situation of Ukraine, we have many different perspectives of transitional justice as such, and the use of international law, since we have at the same time the external aggression of the third state, that the Russian Federation, against Ukraine, and the constant endeavors undertaken by the Ukraine authorities to apply some of the transitional justice mechanisms during the ongoing conflict. So it will be the last part before summary of my today's presentation. If we can move on, I will be very thankful. Yes, so transitional justice as a concept, it became quite popular, or very popular, and even not in the scientific literature, but also in normal, let's say, media during the transformation that took place in my region, so the Central and Eastern Europe in the last, it was the 1989, the year of 1989, and the subsequent years when the communist regime failed firstly in Poland, then in other countries of my region. So during the time Slovakia, right, of course, right now we have two different countries, Czech Republic and Slovakia, Hungary, and other countries of the region. And during those days, basically the American experts, American lawyers, but also experts on the transitional societies, they started to explore the issue of the so-called transitional justice. So the different aspects of instruments of judicial or non-judicial character that shall be applied in the situation when the non-democratic rule is transforming into democracy, or authoritarian, totalitarian rule is collapsing, and democracy, and based on the rule of law principle, is able to be established by the post-violence, post-authoritarian societies. And actually, because this Central and Eastern European transformations, they were kind of an inspiration for scholars, for academicians to commence this research. But in very short time, it appeared that transition in Latin American states, so like in Chile, in Argentina, in Brazil, in Uruguay, in all of those, most of the countries of the continent of South America that were subjected to dictatorships in 1960s, 70s, and 80s, they also started to transform themselves to become a democratic states. And this, let's say, first wave of transitional justice scholarship accented and emphasized on the issue of post-authoritarian states. So states that did not experience a time of an ongoing or just armed conflict, but a time of repressive rule, massive human rights violations, mostly directed at the opposition or democratic opposition to the non-democratic regimes, either in Latin American context or in Central and Eastern Europe during those days. But in 1990s, the situation, mostly due to the armed conflict in the former Yugoslavia, that actually was very brutal, and this conflict lasted for a couple of years between 1991 and 1995, and 1994 in Rwanda, it was a year of genocide that forced international community to find a new way of addressing the massive abuses, massive atrocities, international crimes committed, human rights violations on the large scale witnessed during those days. And transitional justice became more oriented at this post-conflict justice pillar. So we did not talk so much during those days about this, let's say, post-communists or post-authoritarian cases of the transitions in Latin America or in Central and Eastern Europe, but we as scholars on transitional justice moved towards the issue of post-conflict justice. And very often today, transitional justice is understood as a label with the situation of ending the war and moving to peace. Of course, it is true. It is very true, unfortunately, because of the situation of mass atrocities. But I would like to emphasize that transitional justice covers both situations. So not only ongoing or just conflicts, armed conflicts, but also the authoritarian, totalitarian regimes that are as such as living systems. They are affecting the most fundamental rights of people by repressing them, by giving the situation of human rights violations. And if you watch, for instance, right now, media covers from Europe, you can, I think you could find some news from Belarus. So another my country that is neighboring Poland, that actually is facing the, I would say, pre-transitional justice period, when people moved to the streets of different Belarusian cities because of, first of all, falsifications of the presidential elections, and afterwards the brutal reaction of the authorities to the protests. So extreme repressions, human rights violations, including tortures. So in the language of international law, the case of jus cogens or jus cogens, norms that cannot be infringed in any time. There is no possibility to, for instance, justify the use of tortures in any possible case. And since the last 10 years, we have another section of research, and also some efforts of the practical application of transitional justice mechanisms, not only after the conflict is finished, but also during the bloodshed. So when still human rights violations and armed and grave breaches of international humanitarian law are being committed, but still we have this enormous number of scholars working on that issue. And the last thing, transitional justice in the last also 10 years is very closely linked to the efforts of peace building, so after the conflict is ended. If we can move afterwards to the next slide, I would be also very grateful. So far, I spoke about the situation of the last 30 years. So since the transition from authoritarian rule in the Central and Eastern Europe to our days, to the present time. But of course, the significance of transitional justice in the terms of international law and international criminal justice is the Nuremberg trial after the World War II, when even though we can say about very, I would say, numerous negative aspects of Nuremberg trial, it was an example of victor's justice. So only the Third Reich representatives were held accountable in Nuremberg. We didn't put on a trial, for instance, crimes or people who committed crimes on the side of Western alliance, like United States of America, Great Britain, but also Soviet Union. So of course the Nuremberg trial was not an ideal response to mass atrocities, but actually it gave one very strict and very clear answer that war is subjected to international legal evaluation, and crimes committed shall be or people responsible shall be held accountable before either international criminal tribunal or relevant domestic ones. So this criminal retributive justice pillar within transitional justice was rooted and was put on a place during or due to the work and functioning of the tribunal in Nuremberg and in Tokyo, of course, for the people responsible on the far east of those most heinous crimes committed during the Second World War. We can move on to the next slide. Up to date, there is no clear definition of transitional justice. Of course, we can name enormous number of scholars working on the fields that they are giving their own definitions, the scientific academic definitions, but there is no one, let's say, legal definition of transitional justice, for instance, put as a part of some international treaty that is an binding instruments of international for states as subjects of international law and actors on international scene. But in 2004, there was, at least today, very famous report published by the UN Secretary General, named The Rule of Law and Transitional Justice in Conflict and Post-Conflict Societies, when UN Secretary General put this, I would say, definition that corresponds to the situation that can be found in most of the works of scholars, but also the practical application of transitional justice toolkit in different very concrete situations. So we can see here that the notion of transitional justice comprises the full range of processes and mechanisms associated with a society's attempts to come to terms with a legacy of large-scale past abuses in order to ensure accountability, serve justice, and achieve reconciliation. These may include both judicial and non-judicial mechanisms with different levels of international involvement or none at all, and individual prosecutions, reparations, truth-seeking, institutional reforms, vetting and dismissals, or a combination thereof. When we look at this definition, we can see that here the situation of post-authoritarian and post-conflict societies is put under, let's say, one definition, because we can see, for instance, such mechanisms as individual prosecutions that in most of the cases are associated with the situation of conflict or post-conflict societies, or truth-seeking, like truth and reconciliation commissions in most of the cases installed in conflict or post-conflict societies, but also, for instance, such instruments like institutional reforms, vetting or lustration, dismissals, verifications that are they are, let's say, normal for the situation of post-authoritarian societies, mostly like post-communists in my region of Central and Eastern Europe. And here in this definition, we also see the phrase the come to terms with a legacy of large-scale past abuses. In my today's speech, I would like to emphasize and concentrate more that the situation is being slightly in a process of change. I don't want to say that transitional justice will, let's say, jump out of this very classical definition of past abuses, because it's, let's say, the basis of transitional justice efforts. But the situation that I will describe for you in today's presentation is starting to show the importance of transitional justice as kind of an anticipation of toolkit or of comprehensive strategies that shall be let's say that shall be crafted by post or conflict societies for the future. Transitional justice as such is slightly in change, moving from this classical backward-looking justice to the forward-looking justice when we think about the situation of the future of the country. So not just that that the only aim of transitional justice is to come to terms with past evils or deal with the past, but we are dealing with the past because we would like to, as a society, to secure the situation when the violence will not be repeated in the near future. So we, as a post-conflict society, we are obliged by international legal norms to create such a system that will secure and guarantee the non-recurrence of violence in the future. Okay, we can move on to the next slide. Justice versus justice. For most of students of law, for instance, but also other social sciences like political science or social science, justice, and of course right now I'm talking about this kind of response to the massive human rights violations or crimes committed. So I concentrate mostly on the issue of criminal justice. Justice, as in the traditional manner, is always associated with this sort of justice. So the situation when after the crime, a punishment shall be executed. So the a person who is responsible for this most heinous crimes committed in a situation, for instance, during the armed conflict, shall be held accountable before international or domestic relevant court. But transitional justice as such cannot be associated solely and only with the response of this classical criminal justice. Why? Because in post-conflict and also post-authoritarian, but in post-conflict societies, the need of victims is not just to see a person who committed a crime in prison, so convicted by relevant court, but victims' expectations is also to achieve reconciliation, to ensure that the state, after moving from a war to peace, is able to display the truth about the violations, about the reasons that led to the conflict and those international crimes or human rights violations. And that's why sometimes, for instance, the provisions of amnesty are being applied by post-conflict societies. Amnesties are, of course, a very controversial instrument, because by amnesties we agree that some of the people that actually were wrongdoers, so were committing crimes, because of the let's say bigger aim of securing stabilization and achieving peace and reconciliation after the conflict has come to an end, they shall be released from the criminal response, but of course not released and it's just kind of a let's say reward. No, it's international law, modern international law and international criminal law is saying that states first of all is obliged to prosecute and punish people responsible for those international crimes. So of course people who committed war crimes, genocide, crimes against humanity, they should be held accountable in any possible situation, and amnesties shall not be applied and shall not cover those people who committed such crimes. But in a situation when many other residents of different conflict or post-conflict societies were just, let's say, were participating in a conflict in very different directions and circumstances, those people, some people, of course, can be released from the criminal responsibility, but in most of the cases, the state is trying to secure the situation, for instance, by saying that, okay, we can cover you by the amnesty provisions, but first of all, you have to say us everything about the situation that you know about the human rights violations, to testify, to be able to tell us more about facts of those crimes committed. Because in that situation, the possibility of reconciliation between the perpetrators and victims is, at least it is showed by research of different social legal scholars, that is much more of it's much more possible when we apply this very wide range of transitional justice mechanism, not just concentrating solely on the issue of pure retributive justice. Okay, we can move on to the next slide. Very briefly, because I have just explained those different mechanisms, but of course, among those mechanisms, we first of all will say about criminal trials. The criminal trials are actually a direct consequence of international legal obligations of a state to prosecute and punish the perpetrators of human rights violations. Also, the obligation to investigate, to conduct an inquiry, and also by conducting these investigations, the possibility of disclosing the truth about the violations, and maybe even as the next step, reparations for victims is of bigger chance. And also the newest scholarship of transitional justice is taking into consideration and showing this also a slight change for criminal trials from the strictly traditional version of retributive justice to this utilitarian perspective. For instance, by the use of victims, by letting the victims to participate in a formal manner during the trials, for instance, before the International Criminal Court, but also before the extraordinary chambers of Cambodia. There is a possibility for victims to officially be a part of a criminal trial, to seek truth and reparation. The special fund is established within the ICC, the International Criminal Court system. Truth commissions, so the non-judicial aspect of transitional justice, in the past it was seen as a kind of, I would say, a situation of alternative. So either state would commence this criminal, the strategy of criminal prosecutions, or would establish a truth commission without this retributive justice pillar. Today, transitional justice experts agree on the fact that criminal trials and truth commissions can complement each other. So it is not a situation when truth commission is, for instance, a possibility of a state to not to punish perpetrators of human rights violations, mostly of the political reasons, but truth commission can be complementary instruments that can secure the truth, so the disclose of the truth for the society. Because as I mentioned before, victims' expectations also cover the situation of a truth. So without a truth, it can be kind of controversial. For instance, if a state is prosecuting and punishing some concrete people, but without the explanation why we are putting them on trial, it is a chance that the society will not understand and will not follow the strategy of a given state authorities, of a given state, for instance, post-conflict society. So today, I see truth commissions as a possible, as an additional to criminal trials instrument of delivering transitional justice in different conflict and post-conflict societies. We can move on to the next slide. Reparation programs, institutional reforms, vetting. Those instruments are very classical for post-authoritarian states. And for now, there is I would say enough, because our topic is a bit different. So let's move on to the next slide. If we can move on to the next slide. Yes, so moving to this, let's say, core part of my presentation, transitional justice in ongoing conflicts and post-conflict architecture. We have to remember that always in such situations, there is this, let's say, objective international, the language of objective international law, so obligations of a state, and local approaches to justice, when also in different situations can stand in an opposition. Why? Because, for instance, there can be some group of interest in different post-conflict state that are that, for instance, would like to secure their own fellows not to be prosecuted by the post-conflict society. So we always have to remember that transitional justice, even though it's rooted in international law, is always subjected to politics. So it's always a political issue. So even though we have this kind of objective normative anchor of transitional justice, the use of different instruments is a kind of a consequence of a political decision by given authorities. Okay, we can move on to the next slide. Yes, we can skip it. We can move to the next one, because here I just repeated the situation of a shift from this backward-looking justice to the forward-looking justice. Here, of course, comparison of this classical criminal response and truth-telling and truth-seeking processes. But since we don't have so much time, we can move on to the next slide. Okay, and here, by saying about this transitional justice in ongoing conflicts, first and the most, I would say, powerful instruments, especially of the international community during the bloodshed, is then international judicial interventions. As we can look at the history of the 1990s and the armed conflict that was taking place on the territory of former Yugoslavia, we can understand that the International Tribunal, the ICTY, was established by the UN Security Council even during the conflict. So the people that were fighting, that were committing crimes, could expect that their conduct can be put under legal scrutiny and can be legally evaluated by the International Criminal Tribunal. So it is a tool of political or even geopolitical, if we say, about this kind of international conflicts that are affecting not just one state, but for instance the whole region. That's the formation, the establishment of such a court is a tool of political pressure put on the group that are committing crimes. The same situation is witnessed with the functioning of the International Criminal Court, especially in the last 10 years. Because if we can see about the situation of the armed conflicts in Libya after the Arab Spring, or during the Arab Spring, and of 2011, and war that was taking place on the territory of Georgia in 2008 between Russia and Georgia. In those two situations, the ICC prosecutor interfered, even like in the Russo-Georgian war, acting on proprio motu, so by its own initiative, even during the bloodshed. It is extremely important because it gives a possibility and a perspective, the real perspective of putting people that are committing crimes on trial. Of course, from theory and to practice is always a long time. Just to remind you, the Russo-Georgian context of armed conflict of 2008, it took 8 long years for the ICC prosecutor to move from this preliminary examination of the state to the next stage of investigations, and still we are waiting for the first indictments. Of course, not saying anything about the possible prosecutions, but still it is an instrument of criminal justice, but also understood as a part of transitional justice, comprehensive strategies of conflict and post-conflict societies with an international aid, with an international assistance. Also, the Colombian peace process was secured by the assistance of the ICC, and the Ukrainian case also Ukraine by two ad hoc resolutions of the Parliament of Ukraine in 2014, because Ukraine is still not the party to the Rome Statute, asked the prosecutor of the ICC for help to let's say, put on a trial people responsible for war crimes and crimes against humanity committed on the territory of Ukraine after the armed conflict was commenced in the spring of 2014. We can move on to the next slide. This anticipation of transitional justice, even during the bloodshed, is also extremely important for the post-war reconstruction. Why? Because if we, and by saying we, I understand both as an international community, but also as a concrete state or concrete society that is willing to move from war to peace, to anticipate the establishment of different international bodies, especially under the label of peace building, and let's say reintegration processes after the conflict is going to an end. Here, of course, there is the real threat of this peace versus justice dilemma, because peace building efforts are always oriented and achieving peace, and transitional justice is oriented at delivering justice. Those two perspectives can contradict each other, at least sometimes. But when those strategies are applied in a comprehensive manner with a robust mandates of different international administrations established in the conflict or post-conflict scenarios, we can secure this achievement of peace, but also the delivering of justice in terms of criminal and restorative and reparative justice in conflict or post-conflict societies. We can move on to the next slide. Here are just examples of the most powerful United Nations transitional administrations that were established in conflict and post-conflict scenarios. As we can see, there are two examples from your continent, from Asia. So UNTAC in Cambodia and UNTAD in East Timor. Here on the slide, you can see also the situation when the peace building instrument, so the transitional administration which was administration to stabilize situation of a conflict and post-conflict society, to achieve peace, but also was either directly or indirectly inspiring the establishment of typical transitional justice instruments of delivering criminal justice, like in cases of Cambodia or former Yugoslavia and Kosovo as a separate, but it is also former Yugoslavia, but a separate example of different transitional administration. Or for instance, like in the case of East Timor, also it inspired the establishment of Truth and Reconciliation Commission for this country. We can move on to the next example, to the next slide. Here is a very short and brief description of, I would say, the most powerful in achieving its goals transitional administrations for Eastern Slavonia, Baranya, and Western Sirmium. It is a region in Croatia that was, during the war of 1990s, was subjected to the factual occupation of the Serbian de facto regime of Republic of Srpska Krajina. As you can see here, we had a double legitimization in terms of a let's say, legal background of this transitional administration. So it was a consensual agreement by the parties to the conflict, so in that case by Croats and Serbs, but also it was strengthened by the United Nations Security Council resolution. As you may, of course, know as students of international law or practitioners of law as such, United Nations Security Council resolutions in such situations are constructed as a binding instruments, binding parties to these resolutions. So in that case, Croatia and Serbia, that was let's say supporting this Republic of Srpska Krajina, non-recognized regime and illegal states during the war. We can move on to the next slide.
I'm sorry, Tomasz, we are almost at the end of this first session, so we do not have much time for your session. So can you please wrap up with 2 minutes so that we can move on to the next question?
Okay, so yes, just two, 3 minutes. So if you can just move to another slides just for 10 seconds, just to show our listeners. Because as I know, it will be delivered for you, so you can read it afterwards. I don't want to concentrate on these issues mostly. We can move on to the next slides just for a summary. This very brief, my very short take on Ukraine. So we can move on. Here we have, yes, we can also skip this and just last 2 minutes of transitional justice in ongoing conflicts, the case of Ukraine. After the revolution of dignity that took place in 2013 and 2014, which was then an attempt of the Ukrainian society to democratize this country and to, let's say, jump out of the sphere of the Russian influence, the Russian Federation commenced the international armed conflict by annexing Crimea, so the part of the Ukrainian territory, and by occupying constantly, as you can see on the right side of our slides, the part of the eastern Ukraine. So for 7 years, the conflict is taking place in Ukraine. And what is very interesting for our situation, that in 2014, just 2 or 3 days after the escape of the former president of Ukraine, Viktor Yanukovych, to the Russian Federation, the Ukraine parliament asked by issuing an ad hoc resolutions, the International Criminal Court to assist Ukrainian prosecutors to bring to justice people responsible for war crimes and crimes against humanity. Today, after 7 years of the bloodshed, still there is no comprehensive strategy of transitional justice in Ukraine, even though we can say that as I observing the situation, Ukraine is trying to craft this strategy in a very broad manner. So, of course, extending the situation of the need of bringing to justice people responsible for human rights violations, but also to establish the truth about the conflict. And as you can maybe imagine that how difficult it can be, it is a situation when we do not treat as international lawyers this conflict as a non-international armed conflict, but we treat it as an international armed conflict with the direct participants of the third state, which is the Russian Federation. So here you can see that, for instance, asking for help, the International Criminal Court was also perceived as a situation of putting a pressure on the Russian Federation to stop the violence and to move on to the situation of peace. Of course, I understand that we do not have time, so I would like to finish right now my presentation. We can move to the last slide when our listeners can see some information about myself, about me, about my email address, Twitter and Facebook accounts, and ResearchGate account that you can find some of my publications. So thank you for your attention. If you have any of course questions, I will be grateful to answer to all of them. Thank you very much.
Tomasz, though we do not have much time because already our second speaker has arrived. So I will take quickly one or two questions from the participants, and then we will move on to the next session. So participants, please feel free. Tomasz, as you can see, we have two questions. One is why international crime tribunals focus on administration of transitional justice? And another question is, can you please discuss briefly transitional justice with the context of Rohingya?
Okay, but the first question, because I do not see the first question on the chat Zoom.
Yeah. He actually sent me privately. So the question to the speaker is, why international criminal tribunals focus on the administration of transitional justice?
Okay, first of all, I will start with the second question of Rohingya case. I'm pretty sure that you know more and deeper on the situation because you are neighbors of Myanmar, and most of the refugees were moving to Bangladesh from Myanmar, Rohingyas that were subjected to genocide and human rights violations. It is, I would say, it is a use of international law, so the application of Gambia to the International Court of Justice in The Hague. It is a combination of international law as an instrument of, again, legal in terms of this strict legal manner, but also this political pressure put on the state of Myanmar to, let's say, rephrase or reframe its policy towards the national minority of its own citizens, so the people of Rohingya. And here, the situation of transitional justice and Rohingya, I would say that the international assistance, for instance, by this application of to ICJ is extremely important, but without the political will of the authorities in Myanmar to come to terms with its own conduct, with its own conduct leading to the human rights violations and genocide, transitional justice as such won't be possible to be installed as a strategy, because always, as I said before, international law is giving us this kind of a normative anchor, the state's obligations coming from the international treaties or customary law. But the application of very concrete transitional justice mechanisms is always a consequence of a political will of a given state. So in that case, if Myanmar is not willing to, or won't be, let's say, forced by the international community to apply this transitional justice mechanisms, I'm quite pessimist about the possibility and the situation of successful transitional justice in terms of Rohingya.
So should I repeat the second question to you?
Okay, so the first question was about the national tribunals, yes, and transitional justice, as I understood.
Yes.
It's a perfect case of Bangladesh, when the International Crimes Tribunal is a domestic court, even though the statute of your tribunal was framed by very renowned scholars from Germany in 1970s. It is of course, an example of the political will, as I said before, of the country to apply transitional justice in this criminal retributive justice pillar. in the case of crimes like genocide, and genocide is, of course, the main crime committed during the liberation war of Bangladesh in 1971, of course, I would say that's a country which is more willing, or it's more open for the international assistance, is more transparent. In that case, I would always suggest states like post-genocide states to make use of experience of different international actors and international donors and experts. So to be more transparent, because in that case, not so much controversies would be, let's say, discussed over the national tribunal that is established by a given state. So of course, national tribunals, it is, first of all, it is, I would say, exercise of an international obligation of a state to prosecute and punish the perpetrators of the most heinous crimes. Second of all, it is the transitional justice mechanisms. But third, and this is my, let's say, final remark, I would suggest always in such cases of genocide or crimes against humanity to be more open for an international assistance and presence of at least international experts in that field.
Thank you so much, Tomasz, for your insightful lecture, and I hope the students here who came to attend this certificate course got introduced to you, and also the new concept of transitional justice. And we hope to have you again in our program. Thank you so much.
Thank you very much for the invitation, and I apologize for taking too much time, but you know, it's always like, if you are a scholar, you want to talk and talk and talk. So thank you one more time, and again, sorry for having this time limit
Thank you so
infringed.
much.